Minnesota Real Estate Principles Exam Prep. Question 1. If Avery passes the salesperson examination on a spring test date, how long does the candidate generally have to apply for the license before retaking the exam is required for Avery in Northfield involving a fourplex priced at $439,500? Option A. 1 year from passing the examination. Option B. 30 days from passing the examination. Option C. 3 years from passing the examination. Option D. Until the next broker renewal cycle only. The correct answer is option A. 1 year from passing the examination. Minnesota guidance states that the salesperson license application must be made within 1 year after passing the examination. Shorter periods such as 30 days are too restrictive, and longer periods ignore the retake requirement. The broker renewal cycle does not control the candidate's examination validity period. Question 2. If Avery Thompson pays interest only for the first month on a $169,200 loan at 6.5%, approximately what is 1 month's interest? Option A, $1,692. Option B, $916. Option C, $1,371. Option D, $19,950. The correct answer is option B, $916. Monthly interest is calculated by multiplying the loan balance by the annual rate and dividing by 12. Points, tax proration, and front foot value use different formulas and bases. Interest calculations test careful conversion from annual to monthly rates. Question 3. If one broker represents both Quinn Peterson and Skylar Wilson in a residential transaction, what must occur before the broker acts as a dual agent? Option A. Only the seller must consent because the seller listed the property. Option B. The broker may proceed without consent if the commission is reduced. Option C. All parties must give informed consent to the dual agency relationship. Option D. Consent is unnecessary if 2 different salespersons are involved. The correct answer is option C. All parties must give informed consent to the dual agency relationship. Dual agency requires informed consent from the parties because the broker owes duties to both sides and cannot advocate exclusively for either one. A lower commission does not remove the conflict, and 2 salespersons licensed to the same broker can still create dual agency. Seller-only consent is not enough. Question 4. A factory closure outside the neighborhood reduces demand for nearby homes. What type of depreciation does this suggest for Avery in Northfield involving a fourplex priced at $420,000? Option A, physical deterioration only. Option B, a functional obsolescence only. Option C, accession. Option D, external obsolescence. The correct answer is option D, external obsolescence. External obsolescence is value loss caused by factors outside the property, such as economic changes or adverse surroundings. Physical deterioration is wear and tear, while functional obsolescence is internal design deficiency. A factory closure is external to the property. Question 5. Which Minnesota tax is generally associated with recording a deed that conveys real property for Harper and Moorhead involving a fourplex priced at $206,000? Option A, state deed tax. Option B, mortgage registry tax only. Option C, utility franchise fee. Option D, federal gift tax return fee. The correct answer is option A, state deed tax. Deed tax is generally associated with recording a deed conveying real property. Mortgage registry tax relates to mortgage debt, while utility franchise and federal gift tax issues are outside the ordinary deed recording charge. The transaction document determines which tax applies. Question 6. A city special assessment for a new sidewalk appears on a property record. What kind of charge is it most like for Blair in Bloomington involving a condominium unit priced at $360,000? Option A, a private broker commission split. Option B, a charge against benefited property for a public improvement. Option C, a personal credit card debt. Option D, a title insurance premium refund. The correct answer is option B, A charge against benefited property for a public improvement. A special assessment is commonly charged against properties that benefit from a public improvement. It is not a broker split, personal consumer debt, or title insurance refund. Assessments can affect closing and ownership costs. Question 7. A buyer credit on a closing statement for assumed unpaid taxes generally does what for Emerson in Duluth involving a farm parcel priced at $393,500? Option A. Increases the seller's loan payoff. Option B. Eliminates title insurance. Option C. Reduces the buyer's cash needed because the buyer will later pay the tax bill. Option D. Creates a new listing agreement. The correct answer is option C. Reduces the buyer's cash needed because the buyer will later pay the tax bill. A buyer credit reduces cash due from the buyer when the buyer assumes a future obligation connected to the seller's ownership period. Loan payoff, title insurance, and listing agreements are separate closing or contract issues. Credits and debits must be read from the party's perspective. Question 8. A deed expressly creates survivorship between co-owners of a fourplex. Which ownership feature is being emphasized for Cameron in St. Cloud involving a fourplex priced at $232,000? Option A. No right to possess the property. Option B. A tenant's trade fixture right. Option C. A mortgagee's foreclosure priority. Option D. Right of survivorship in joint tenancy. The correct answer is option D. Right of survivorship in joint tenancy. Joint tenancy is associated with right of survivorship when properly created. Co-owners generally have possession rights, and trade fixtures concern tenants rather than co-owner succession. Mortgage priority is a lien issue, not survivorship ownership. Question 9. A buyer agrees with the lender to become personally liable on the seller's existing mortgage. What is the buyer doing for Riley and Red Wing involving a lake cabin priced at $328,000? Option A. Assuming the mortgage. Option B. Taking subject to the mortgage only. Option C. Creating an easement appurtenant. Option D. Paying deed tax only. The correct answer is option A. Assuming the mortgage. Mortgage assumption involves the buyer taking personal responsibility for the existing loan obligation with lender involvement. Taking subject to a mortgage lacks personal liability to the lender. Easements and deed taxes do not describe assuming debt. Question 10. A seller says the basement is perfectly dry despite knowing of repeated water intrusion. Why is that more than ordinary puffing for Emerson in Duluth involving a condominium unit priced at $399,000? Option A. It is always protected opinion regardless of knowledge. Option B. It is a factual misrepresentation about a material property condition. Option C. It is allowed if the buyer gets a loan. Option D. It becomes legal if stated verbally instead of in writing. The correct answer is option B. It is a factual misrepresentation about a material property condition. A specific false statement about a known material condition can be misrepresentation. Puffing is general opinion, not a false factual claim about water problems. Financing approval or verbal delivery does not make a known material misstatement acceptable. Question 11. A licensee in Winona wants to know which required continuing education topics must be included in the renewal cycle along with the general module for Kendall in Winona involving a small retail building priced at $352,500. Option A. Only appraisal theory and mortgage underwriting. Option B. Only property insurance and income tax preparation. Option C. Agency law and fair housing. Option D. Only construction codes and zoning administration. The correct answer is option C. Agency law and fair housing. Minnesota renewal requirements include agency representation and disclosure training and fair housing training as part of the required education mix. Appraisal, insurance, tax, construction, and zoning topics may be useful, but they do not replace those mandated topics. The rule is designed to keep licensees current on representation and anti-discrimination duties. Question 12. Which document is used to convey ownership of real property from grantor to grantee for Morgan and Brainerd involving a newly built townhouse priced at $243,500? Option A. Promissory note. Option B, listing presentation. Option C, home inspection checklist. Option D, deed. The correct answer is option D, deed. A deed is the instrument used to convey title from grantor to grantee. A promissory note creates a debt promise, a listing presentation markets services, and an inspection checklist reports property condition. Conveyance and financing documents have different functions. Question 13. In Bloomington, a new applicant asks which combination best describes the salesperson licensing path in Minnesota for Blair and Bloomington involving a condominium unit priced at $357,500. Option A. Be at least 18, complete courses 1, 2, and 3, pass the exam, associate with a broker, and receive Commerce Department approval. Option B. Be at least 21, complete only course I, and work independently after passing the exam. Option C. Complete continuing education before any pre-license education and apply directly without a broker. Option D. Pass only the national exam and begin practicing while the application is pending. The correct answer is option A. Be at least 18, complete courses 1, 2, and 3, pass the exam, associate with a broker, and receive Commerce Department approval. Minnesota salesperson licensing requires age eligibility, 3 30-hour pre-license courses, examination success, broker association, and approval by the Commerce Department. The other choices either remove required courses, allow independent practice, or treat a pending application as authority to act. Those alternatives do not satisfy the licensing sequence. Question 14. A facilitator working with Rowan in Minneapolis performs services without representing either side. Which fiduciary duty generally remains unless expanded by written agreement? Option A. Loyalty to the seller only. Option B. Confidentiality. Option C. Obedience to the buyer's investment goals. Option D. Advocacy for the party paying the commission. The correct answer is option B. Confidentiality. A facilitator does not act in a fiduciary capacity as a buyer's broker, seller's broker, or dual agent, but confidentiality remains a duty unless the relationship is expanded by written agreement. Loyalty, obedience, and advocacy belong to agency representation, not ordinary facilitator status. Commission payment does not create fiduciary representation by itself. Question 15. A legal description begins at a point of beginning and follows distances and directions around the boundary. Which system is used for Reese in Minneapolis involving a lake cabin priced at $217,000? Option A. Gross rent multiplier. Option B. Capitalization rate. Option C. Meets and bounds. Option D. Straight line depreciation. The correct answer is option C. Meets and bounds. Meets and bounds descriptions trace boundaries using distances, directions, and a point of beginning. GRM, cap rate, and depreciation are valuation concepts. The boundary walking format identifies the legal description method. Question 16. A salesperson tells owners in Mankato to sell quickly because people from a protected class are moving nearby. What prohibited practice does this describe for Rowan in Mankato involving a lake cabin priced at $308,000? Option A. Reconciliation. Option B. Hypothecation. Option C. Assemblage. Option D. Blockbusting. The correct answer is option D. Blockbusting. Blockbusting uses fear or panic about protected class changes to induce owners to sell or rent. Reconciliation is an appraisal step. Hypothecation pledges property as loan security, and assemblage combines parcels. The key issue is discriminatory pressure on owners. Question 17. An easement benefits a neighboring parcel by allowing driveway access across Taylor Thompson's land. What type of easement is most likely? Option A. Easement appurtenant. Option B. Personal license only. Option C. Trade fixture. Option D. A mechanic's lien. The correct answer is option A. Easement appurtenant. An easement appurtenant benefits another parcel and usually runs with the land. A personal license is revocable permission, a trade fixture is tenant property, and a mechanic's lien secures payment for improvements. The presence of a benefited parcel points to an appurtenant easement. Question 18. At closing, why are prepaid property taxes or rents commonly prorated between buyer and seller for REIS in Minneapolis involving a lake cabin priced at $335,000? Option A. To change the sales price after acceptance. Option B. To allocate income or expenses to the party who owned the property during the relevant time period. Option C. To avoid recording the deed. Option D. To eliminate the need for title insurance. The correct answer is option B. To allocate income or expenses to the party who owned the property during the relevant time period. Priorations allocate recurring income and expenses based on the period each party is entitled to or responsible for them. They do not rewrite the price, avoid recording, or replace title insurance. Closing statements use debits and credits to make this allocation. Question 19. A retail tenant pays base rent plus a percentage of monthly sales. What lease type is described for Taylor in Maple Grove involving a duplex priced at $361,000? Option A. Ground lease only. Option B. Graduated deed. Option C. Percentage lease. Option D. Quitclaim lease. The correct answer is option C. Percentage lease. A percentage lease includes rent based partly on the tenant's sales, commonly in retail settings. A ground lease involves leasing land, and the other terms are not standard lease classifications. The sales volume rent formula is the key clue. Question 20. A buyer includes an inspection condition in a Minneapolis purchase agreement. What is the role of that contingency for REIS in Minneapolis involving a single-family home priced at $215,000? Option A. It automatically transfers title to the buyer. Option B. It eliminates the need for earnest money accounting. Option C. It makes the broker a home inspector. Option D. It makes the buyer's duty to perform depend on the stated inspection condition being satisfied or waived. The correct answer is option D. It makes the buyer's duty to perform depend on the stated inspection condition being satisfied or waived. A contingency is a condition that must be satisfied, waived, or otherwise resolved for the contract obligations to proceed as written. It does not transfer title or remove trust accounting duties. The broker does not become the inspector merely because the contract contains an inspection contingency. Question 21. A lender draws a line around a Rice neighborhood and refuses otherwise qualified mortgage applicants there. What fair housing and lending term best fits for Finley in Bemidji involving a farm parcel priced at $471,000? Option A. Redlining. Option B. Plottage. Option C. Accretion. Option D. Estoppel. The correct answer is option A. Redlining. Redlining is denying or limiting credit in an area for discriminatory reasons rather than evaluating individual qualifications. Plottage relates to value from assemblage, accretion is natural land buildup, and estoppel prevents inconsistent claims. Area-based discriminatory lending violates fair lending principles. Question 22. If annual property taxes of $4,450 are prorated to the seller for 222 days on a 365-day basis, approximately what amount is charged to the seller? Option A. $15,906. Option B. $2,707. Option C. $3,818. Option D. $1,113. The correct answer is option B. $2,707. Tax prioration divides the annual tax by 365 and multiplies by the number of seller days. Commission, discount points, and monthly interest are unrelated calculations. Prioration allocates an annual expense fairly between buyer and seller at closing. Question 23. A broker learns that a foundation defect could significantly affect Finley Garcia's use of a farm parcel in Bemidji. What should the broker do? Option A. Stay silent because the defect might reduce the seller's price. Option B. Disclose only after closing if the buyer complains. Option C. Disclose the material fact to the prospective purchaser. Option D. Treat the defect as confidential even if it affects use and enjoyment. The correct answer is option C. Disclose the material fact to the prospective purchaser. Known material facts that could adversely and significantly affect an ordinary buyer's use or enjoyment must be disclosed. Protecting a sale price does not excuse non-disclosure, and waiting until after closing defeats the purpose of the rule. Confidentiality does not cover facts that law requires to be disclosed. Question 24. A Minnesota landlord withholds a deposit for faded paint caused by normal use. Why is that deduction questionable for Parker and Blaine involving a small retail building priced at $236,500? Option A. Deposits may be withheld only for broker commissions. Option B. All paint changes are automatically tenant damage. Option C. The tenant must buy the property to get the deposit back. Option D. Normal wear and tear is not a proper basis for withholding a security deposit. The correct answer is option D. Normal wear and tear is not a proper basis for withholding a security deposit. Security deposit deductions are for items such as unpaid rent or damage beyond ordinary wear and tear. Normal fading from ordinary use is not the same as tenant-caused damage. Broker commissions and purchase rights are unrelated to residential deposit accounting. Question 25. Under federal fair housing law, which group is a protected class in the sale or rental of housing for Finley and Bemidji involving a farm parcel priced at $407,500? Option A. Familial status. Option B. Credit score above 700. Option C. Preference for lakefront homes. Option D. Employment in real estate sales. The correct answer is option A. Familial status. Familial status is a protected class under federal fair housing law. Credit score, housing preferences, and occupation in real estate are not protected classes by themselves. Housing decisions must avoid discrimination based on protected characteristics. Question 26. A utility company has the right to run power lines across a Bloomington parcel. Which property right is usually involved for Blair in Bloomington involving a condominium unit priced at $266,000? Option A. Estate for years. Option B. Easement in gross. Option C. Devolution. Option D. A remainder interest. The correct answer is option B. Easement in gross. A utility easement often benefits a company rather than a neighboring parcel, making it an easement in gross. An estate for years is a leasehold, a avulsion is sudden land change, and a remainder follows a life estate. The utilities right is a non-possessory use right. Question 27. An advertisement says a vacant lot is available only for adults with no children. What is the main fair housing concern for Quinn and Eden Prairie involving a vacant lot priced at $270,000? Option A. The ad forgot to mention the roof age. Option B. The ad uses a list price instead of an appraised value. Option C. The statement indicates a preference or limitation based on familial status. Option D. The ad includes the city name. The correct answer is option C. The statement indicates a preference or limitation based on familial status. Advertising cannot indicate a discriminatory preference or limitation based on familial status except where a valid housing for older persons exemption applies. Roof age, list price, and city name are not the fair housing issue in the wording. The problem is discouraging families with children. Question 28. An appraiser adjusts comparable sales for differences from the subject property. Which approach is being applied for Parker and Blaine involving a townhome priced at $278,500? Option A. Cost approach only. Option B. Income approach only. Option C. Mortgage registry method. Option D. Sales comparison approach. The correct answer is option D. Sales comparison approach. The sales comparison approach compares the subject to similar sold properties and adjusts for differences. Cost and income approaches use different inputs, and mortgage registry tax is not an appraisal method. Comparable sale adjustment is a core valuation technique. Question 29. A rental property produces $30,000 in net operating income and investors require a 7% capitalization rate. What value is indicated by the income approach? Option A. $428,571. Option B. $154,000. Option C. $357,300. Option D. $54,600. The correct answer is option A, $428,571. The income approach using direct capitalization divides net operating income by the capitalization rate. Gross rent multiplier, loan amount, and frontage calculations use different inputs. The cap rate converts expected net income into an indicated value. Question 30. Which deed gives Finley Davis the broadest set of title warranties from the grantor? Option A, quitclaim deed. Option B, general warranty deed. Option C, bargain and sale deed with no covenants. Option D, tax certificate only. The correct answer is option B, general warranty deed. A general warranty deed provides the strongest customary covenants of title from the grantor. A quitclaim deed conveys whatever interest the grantor has without warranties. A bargain and sale deed without covenants and a tax certificate provide less assurance than a general warranty deed. Question 31. A buyer pays 2.5% in discount points on a $283,200 loan. Approximately how much are the points? Option A, $1,475. Option B, $70,800. Option C, $7,080. Option D, $17,700. The correct answer is option C, $7,080. One discount point equals 1% of the loan amount, so the points are calculated by multiplying the loan amount by the point percentage. Monthly interest, down payment, and commission are calculated from different formulas. The point charge is a loan cost calculation, not a sales commission or equity contribution. Question 32. In a gross lease for a St. Cloud office, which cost structure is most typical for Cameron and St. Cloud involving a duplex priced at $280,000? Option A. The tenant pays all property taxes, insurance, and maintenance separately. Option B. The tenant receives title at the end of the lease. Option C. The rent is based only on retail sales volume. Option D. The landlord pays most property operating expenses from the rent received. The correct answer is option D. The landlord pays most property operating expenses from the rent received. In a gross lease, the landlord typically pays most operating expenses and receives rent as a gross amount. Net leases shift more expenses to the tenant, and percentage leases tie rent partly to sales. A lease does not transfer title merely because it is gross. Question 33. Two investors own a Moorhead duplex with unequal shares and no survivorship language. Which ownership form is most likely for Harper and Moorhead involving a fourplex priced at $308,500? Option A, tenancy in common. Option B, tenancy by the entirety. Option C, severalty. Option D, life tenancy only. The correct answer is option A, tenancy in common. Tenancy in common allows unequal ownership shares and has no automatic right of survivorship. Severalty means one owner, and a life tenancy is measured by a life. Tenancy by the entirety is a special marital form not described by unequal investor shares. Question 34. Recording a deed for a mixed-use property in Hennepin County primarily gives what type of notice to the public? Option A, private notice only to the buyer's lender. Option B, constructive notice. Option C, a zoning variance. Option D, a guarantee of physical condition. The correct answer is option B, constructive notice. Recording places an instrument in the public records and gives constructive notice of the recorded interest. It does not create a zoning variance or guarantee the property's physical condition. The public records system protects priority and notice, not building quality. Question 35. A buyer brings certified funds for price, closing costs, and prepaid items after lender credits are applied. What is this amount commonly called for Kendall in Winona involving a townhome priced at $443,500? Option A, gross rent multiplier. Option B, a functional obsolescence. Option C, cash to close. Option D, protective list. The correct answer is option C, cash to close. Cash to close is the amount the buyer must bring to complete the transaction after credits, loan proceeds, and closing charges are calculated. GRM is an appraisal shortcut, functional obsolescence is depreciation, and a protective list relates to override clauses. The question is about closing settlement funds. Question 36. Unless the parties' written agreement says otherwise, when should a Minnesota listing broker deposit earnest money after receiving it and final acceptance has occurred for Avery in Northfield involving a fourplex priced at $402,000? Option A. Only after the buyer's loan is fully underwritten. Option B. At any time before the deed is recorded. Option C. Within 30 calendar days after the first showing. Option D. Within 3 business days of receipt or final acceptance, whichever is later. The correct answer is option D. Within 3 business days of receipt or final acceptance, whichever is later. Minnesota trust account rules provide a default deadline of 3 business days after receipt or final acceptance, whichever is later, when the written agreement is silent. Waiting for underwriting, recording, or an arbitrary 30-day period would not meet that default rule. The parties can address timing in their written agreement. Question 37. A Minneapolis salesperson wants to place personal money in the broker trust account to save for taxes. Why is that improper for Reese in Minneapolis involving a mixed-use property priced at $403,000? Option A. Trust accounts may contain only trust funds except limited identified funds for service charges or minimum balance requirements. Option B. Personal funds must always be kept in the listing broker's trust account. Option C. Salespersons may use trust accounts as savings accounts with broker consent. Option D. Commingling is allowed when the amount is less than 1 month's rent. The correct answer is option A. Trust accounts may contain only trust funds except limited identified funds for service charges or minimum balance requirements. Trust accounts are for trust funds, with only limited identified personal funds allowed for service charges or minimum balance requirements. Using the account as a personal savings account would commingle funds. Broker consent or a small amount does not change the commingling rule. Question 38. A garage built on Drew Lee's land extends 2 feet over the boundary onto a neighbor's parcel. What issue is created? Option A. Hypothecation. Option B. Encroachment. Option C is subrogation. Option D. Reconciliation. The correct answer is option B. Encroachment. An encroachment occurs when an improvement physically intrudes onto another parcel. Hypothecation pledges property for debt, subrogation substitutes one party's claim, and reconciliation is an appraisal conclusion step. The garage crossing the boundary is the key fact. Question 39. If assessed value is $372,000 and the tax rate is 22 mils, what is the annual property tax? Option A. $1,831. Option B. $4,882. Option C. $8,184. Option D. $139,500. The correct answer is option C. $8,184. A mil is $1 per $1,000 of assessed value, so the tax is assessed value multiplied by mils divided by 1,000. Monthly interest, points, and down payment are financing calculations. Millage questions require converting mils to a decimal rate. Question 40. Which ownership estate gives Casey Nolan the greatest bundle of rights with no stated end date or condition for Casey in Stillwater involving a farm parcel priced at $218,500? Option A. Estate at sufferance. Option B. Life estate. Option C. License. Option D. Fee simple absolute. The correct answer is option D. Fee simple absolute. Fee simple absolute is the broadest ownership estate and can continue indefinitely. A life estate ends with a measuring life, an estate at sufferance arises from holdover possession, and a license is permission rather than an estate. The key phrase is ownership without a stated end date or condition. Question 41. A borrower signs a promissory note and mortgage to finance a Woodbury home. What does the note do for Drew in Woodbury involving a single-family home priced at $202,500? Option A. Creates the borrower's personal promise to repay the debt. Option B. Transfers title to the lender at closing. Option C. Sets the zoning classification. Option D. Records the deed tax payment. The correct answer is option A. Creates the borrower's personal promise to repay the debt. The promissory note is the borrower's promise to repay according to the loan terms. The mortgage secures that promise with a lien on the property. Zoning, title transfer, and deed tax are separate matters. Question 42. A landlord receives a forwarding address after a tenant leaves a Minnesota rental. What deadline is commonly tested for returning the deposit or giving a written explanation for Quinn in Eden Prairie involving a condominium unit priced at $396,000? Option A. Within 1 year after the lease began. Option B. Within 21 days after the tenancy ends, assuming the forwarding address requirement is met. Option C. Only at the next property tax settlement. Option D. Whenever the landlord sells the building. The correct answer is option B. Within 21 days after the tenancy ends, assuming the forwarding address requirement is met. Minnesota landlord-tenant materials commonly test the 21-day security deposit return or explanation period after the tenancy ends and the forwarding address is provided. Waiting for a tax settlement, building sale, or 1-year mark does not match the standard rule. The landlord must account for the deposit promptly. Question 43. A buried heating oil tank is discovered during inspection of a small retail building. Why is this important for Hayden in Rochester involving a small retail building priced at $264,500? Option A. They automatically convert the property to personal property. Option B. They prove the deed is forged. Option C. Underground storage tanks can create environmental and cleanup concerns that may affect value and use. Option D. They eliminate all mortgage requirements. The correct answer is option C. Underground storage tanks can create environmental and cleanup concerns that may affect value and use. Underground storage tanks may involve leaks, regulatory requirements, and cleanup costs, making them material environmental concerns. They do not convert real estate into personal property, prove deed fraud, or remove financing requirements. Environmental issues can affect value, marketability, and buyer decisions. Question 44. In a lien theory mortgage state such as Minnesota, what does the mortgage usually give the lender for Finley in Bemidji involving a condominium unit priced at $238,000? Option A. Immediate ownership and possession of the property. Option B. A life estate measured by the borrower's life. Option C. A leasehold estate for the loan term. Option D. A lien securing repayment while the borrower retains title. The correct answer is option D. A lien securing repayment while the borrower retains title. In lien theory, the mortgage gives the lender a security lien rather than immediate title and possession. The borrower retains legal title unless foreclosure changes ownership. Life estates and leaseholds are different interests, not the ordinary mortgage relationship. Question 45. In a dual agency situation in Bemidji, why must the licensee avoid advocating exclusively for one party? Option A. The broker owes duties to both buyer and seller within the limits of dual agency. Option B. The broker becomes a government mediator. Option C. The buyer automatically becomes the broker's only client. Option D. The seller's broker relationship disappears at acceptance. The correct answer is option A. The broker owes duties to both buyer and seller within the limits of dual agency. Dual agency means the broker owes duties to both sides and must work within those limits. The broker is not converted into a government mediator, and neither party becomes the only client. Acceptance of an offer does not eliminate the agency relationship or the disclosure limits. Question 46. A buyer takes title while the seller's existing loan remains in place, but the buyer does not become personally liable to the lender. What phrase best describes this for Jordan in Edina involving a lake cabin priced at $267,500? Option A. Assuming the mortgage with release. Option B. Taking subject to the mortgage. Option C. Creating a life estate. Option D. Recording a quitclaim covenant. The correct answer is option B. Taking subject to the mortgage. Taking subject to a mortgage means the property remains security for the debt, but the buyer does not personally promise the lender to pay. Assumption involves personal liability unless otherwise released. Life estates and quitclaim covenants are unrelated to this financing arrangement. Question 47. A licensee in Eden Prairie drafts a complex legal clause for Quinn Garcia instead of recommending legal counsel. What risk is created? Option A, constructive eviction. Option B, of functional obsolescence. Option C, unauthorized practice of law. Option D, inverse condemnation. The correct answer is option C, unauthorized practice of law. Licensees may fill in approved forms and explain business terms, but drafting legal clauses can cross into unauthorized practice of law. Constructive eviction, functional obsolescence, and inverse condemnation describe different legal or valuation issues. Complex legal drafting should be handled by an attorney. Question 48. What is the main purpose of an owner's title insurance policy for Kendall Patel? Option A, to insure the roof against storm damage. Option B, to guarantee future market appreciation. Option C, to replace the need for a purchase agreement. Option D, to protect against covered title defects that existed before the policy date. The correct answer is option D, to protect against covered title defects that existed before the policy date. Owner's title insurance protects against covered past title defects, liens, or ownership issues discovered after closing. It is not property casualty insurance, an appreciation guarantee, or a substitute for the purchase contract. Title insurance focuses on ownership risk, not physical damage or investment performance. Question 49. A deed gives Blair possession for life, then ownership passes to Emerson Miller. What interest does Emerson Miller hold before Blair's death? Option A, remainder interest. Option B, leasehold estate. Option C, easement in gross. Option D, mortgage lien. The correct answer is option A, remainder interest. A remainder interest is a future interest that becomes possessory after a life estate ends. A leasehold is a tenant's possession, an easement in gross is a use right, and a mortgage lien secures debt. The buyer's right follows the life tenant's measuring life. Question 50. If Kendall Wilson tells the licensee that the seller will not perform under the signed purchase agreement, what must the licensee do? Option A, keep the information confidential until the closing date. Option B, immediately disclose the stated intent not to perform to the other party or parties. Option C, cancel the agreement without telling the buyer. Option D, disclose only if the seller misses a loan contingency. The correct answer is option B, immediately disclose the stated intent not to perform to the other party or parties. A licensee put on notice that a party will not perform according to the transaction agreement must disclose that intent to the other party or parties. Keeping the information secret would mislead the other side. The rule is different from a party's inability to satisfy a contingency. Question 51. A mortgage contains a clause allowing the lender to call the full balance due after default. What clause is this for Riley and Red Wing involving a mixed-use property priced at $275,500? Option A, Habendum Clause. Option B, Quiet Enjoyment Clause. Option C, Acceleration Clause. Option D, Substitution Clause in Appraisal. The correct answer is option C, Acceleration Clause. An acceleration clause allows the lender to demand the entire debt after default. A habendum clause is associated with deeds, quiet enjoyment appears in leases, and substitution in appraisal is a valuation principle. The trigger is borrower default. Question 52. A licensee directs families with children only toward one area of Blaine. What fair housing problem does that conduct create for Parker and Blaine involving a townhome priced at $401,500? Option A, amortization. Option B, subordination. Option C, novation. Option D, steering. The correct answer is option D, steering. Steering occurs when a real estate professional guides prospects toward or away from areas based on a protected characteristic. Amortization is loan repayment, subordination is lien priority adjustment, and novation is contract substitution. The conduct described limits housing choice and raises fair housing risk. Question 53. At closing, a seller debit for unpaid property taxes usually means what for Schuyler and Egan involving a small retail building priced at $377,500? Option A. The seller is being charged for the portion owed for the seller's period of ownership. Option B. The buyer is paying the seller's commission twice. Option C. The lender has forgiven the loan. Option D. The deed has failed to convey title. The correct answer is option A. The seller is being charged for the portion owed for the seller's period of ownership. A seller debit reduces the seller's proceeds for an amount the seller owes, such as the seller's share of property taxes. It does not double a commission, forgive a loan, or prove the deed failed. Debits and credits allocate amounts between the parties. Question 54. A lender offers Jordan Chen a mortgage whose interest rate can change based on an index after an initial period. What type of loan is this? Option A. Package mortgage only. Option B. Adjustable rate mortgage. Option C. Open-end listing. Option D. A graduated lease. The correct answer is option B. Adjustable rate mortgage. An adjustable rate mortgage has an interest rate that may change according to an index and loan terms. A package mortgage includes personal property, an open-end listing is not a standard listing type, and a graduated lease changes rent over time. The index-based interest change identifies the loan type. Question 55. If a St. Cloud property sells for $445,000 and the buyer obtains an 80% loan, what is the buyer's down payment? Option A. $356,000. Option B. $24,475. Option C. $89,000. Option D. $2,478. The correct answer is option C. $89,000. The down payment is the sale price minus the loan amount. The loan amount is the financed portion, the commission is a brokerage compensation calculation, and the tax proration allocates property taxes. Separating buyer equity from loan proceeds is a core exam math skill. Question 56. A tenant with a disability asks for an assigned accessible parking space near the entrance. What fair housing concept is most directly involved for Blair in Bloomington involving a farm parcel priced at $298,500? Option A. Adverse possession. Option B. Yield spread premium. Option C. Defeasance clause. Option D. Reasonable accommodation. The correct answer is option D. Reasonable accommodation. A reasonable accommodation is a change in rules, policies, or services that may be needed for a person with a disability to use and enjoy housing. Adverse possession concerns ownership claims, yield spread premiums concern loan compensation, and defeasance clauses concern loan satisfaction. The requested parking change involves access to housing. Question 57. A lot has 185 front feet worth $190 per front foot. What is the indicated front foot value? Option A. $35,150. Option B. $3,788. Option C. $29,344. Option D. $752,941. The correct answer is option A. $35,150. Front foot valuation multiplies frontage by the price per front foot. Tax proration, commission, and income capitalization rely on other formulas. The question asks only for the land value indicated by frontage. Question 58. Why is the Minnesota agency disclosure form given to Sawyer and Gwynn not enough by itself to create representation? Option A. It automatically creates dual agency for every transaction. Option B. It is a disclosure only, and representation requires a written listing contract or buyer representation contract. Option C. It replaces all purchase agreement requirements. Option D. It gives the consumer a license to sell property. The correct answer is option B. It is a disclosure only, and representation requires a written listing contract or buyer representation contract. The agency disclosure form informs consumers about relationship options but does not create representation. Representation requires a written contract such as a listing agreement or buyer representation contract. The other choices confuse disclosure with dual agency, purchase contracts, or licensing authority. Question 59. A legal description refers to township, range, and section. Which survey system is being used for Blair in Bloomington involving a condominium unit priced at $454,000? Option A, meets and bounds only. Option B, lot and block only. Option C, rectangular government survey system. Option D, a gross lease system. The correct answer is option C, rectangular government survey system. The rectangular government survey system uses townships, ranges, and sections. Meets and bounds relies on boundary calls, and lot and block relies on subdivision plats. Gross lease is a lease structure, not a land description system. Question 60. Under the Minnesota Human Rights Act, which protected basis expands beyond the traditional federal fair housing list for Blair in Bloomington involving a farm parcel priced at $235,000? Option A, preference for a short commute. Option B, owning 2 vehicles. Option C, having a fixed-rate mortgage. Option D, status with regard to public assistance. The correct answer is option D, status with regard to public assistance. Minnesota housing and real property discrimination law includes status with regard to public assistance among protected bases. Commute preference, vehicle ownership, and mortgage type are not protected classes. State law can add protections beyond the federal baseline. Question 61. A broker compares a buyer's desired use with zoning rules, parcel size, and market demand. What appraisal principle is being considered for Reese in Minneapolis involving a mixed-use property priced at $388,500? Option A, highest and best use. Option B, tie-in arrangement. Option C, novation. Option D, steering. The correct answer is option A, highest and best use. Highest and best use evaluates legal permissibility, physical possibility, financial feasibility, and maximum productivity. Tie-in arrangements, novation, and steering involve antitrust, contract substitution, and fair housing concerns. The analysis is about the most supportable property use. Question 62. A built-in dishwasher is attached and adapted to a vacant lot. What is it most likely considered in a sale for Finley in Bemidji involving a vacant lot priced at $350,000? Option A, emblement. Option B, fixture. Option C, trade name. Option D, license. The correct answer is option B, fixture. A fixture is personal property that has become real property through attachment, adaptation, intent, or agreement. Emblements are crops, a trade name is business identity, and a license is permission. Built-in appliances are commonly analyzed as fixtures. Question 63. In appraisal, what does highest and best use require for Sawyer in St. Paul involving a rental house priced at $233,500? Option A, the use that produces the highest commission. Option B, the use preferred by the current tenant only. Option C, a use that is legally permissible, physically possible, financially feasible, and maximally productive. Option D, the use with the lowest property tax bill. The correct answer is option C, a use that is legally permissible, physically possible, financially feasible, and maximally productive. Highest and best use considers legal, physical, financial, and productivity tests. Commission, tenant preference, and tax savings alone do not determine highest and best use. The concept focuses on the most supportable use of the property as real estate. Question 64. A lender requires private mortgage insurance because Finley Chen's conventional loan has a high loan-to-value ratio. What does PMI primarily protect? Option A, the buyer against title defects. Option B, the seller against market depreciation. Option C, the appraiser against negligence claims. Option D, the lender against part of the risk of borrower default. The correct answer is option D, the lender against part of the risk of borrower default. Private mortgage insurance protects the lender when a conventional loan has higher default risk due to low borrower equity. It does not protect the buyer's title, guarantee the seller's price, or insure an appraiser's liability. Borrowers often pay for PMI, but the lender is the protected party. Question 65. A buyer purchases a $275,500 property with an 85% loan. What is the approximate loan amount? Option A, $234,175. Option B, $41,325. Option C, $15,152. Option D, $5,000. The correct answer is option A, $234,175. Loan amount is found by multiplying the sale price by the loan-to-value percentage. Down payment is the remaining equity, commission is based on brokerage compensation, and annual tax is a government charge. The loan-to-value percentage controls the financing amount. Question 66. Regarding commission language in a Minnesota listing agreement, which statement best reflects the required consumer notice for Emerson in Duluth involving a vacant lot priced at $254,000? Option A. The state sets one mandatory commission rate for all residential listings. Option B. Compensation is determined between each individual broker and the broker's client. Option C. The MLS sets the minimum commission for every listing. Option D. The buyer must always pay the listing broker directly. The correct answer is option B. Compensation is determined between each individual broker and the broker's client. Minnesota listing agreements must include a notice that compensation is determined between the broker and the broker's client. The state and MLS do not set a universal commission rate for every transaction. Payment arrangements depend on the agreement and cannot be assumed from the listing alone. Question 67. Which event usually allows trust funds in a Minnesota real estate transaction to be disbursed for Kendall and Winona involving a townhome priced at $432,500? Option A. A verbal request from one salesperson. Option B. A social media announcement that the deal is done. Option C. Closing of the transaction, written agreement of the parties, statutory affidavit, or court order. Option D. The buyers hope to renegotiate after closing. The correct answer is option C. Closing of the transaction, written agreement of the parties, statutory affidavit, or court order. Trust funds may be disbursed only under recognized authority such as closing, written agreement, applicable statutory affidavit, or court order. A verbal request or social media post does not provide the necessary authority. A buyer's later wish to renegotiate is not a trust fund disbursement event. Question 68. Under Chapter 82 standards, what must a broker do to properly supervise salespersons at a Winona office for Kendall and Winona involving a small retail building priced at $376,000? Option A. Let each salesperson approve their own contracts without broker review. Option B. Delegate all trust records to buyers and sellers. Option C. Supervise only advertising and ignore purchase agreements. Option D. Monitor brokerage activities, review transaction documents, and review trust account books and records. The correct answer is option D. Monitor brokerage activities, review transaction documents, and review trust account books and records. Broker supervision includes ongoing monitoring of salespersons, transaction documents, and trust account records. Salespersons do not self-supervise, and clients are not responsible for brokerage trust accounting. Limiting supervision to advertising would miss major broker responsibilities. Question 69. When Emerson, a licensee, intends to buy a client's property in Eden Prairie, what disclosure is required before negotiation or consummation? Option A. The licensee must affirmatively disclose the license status and the capacity in which the licensee is acting. Option B. The licensee may stay silent if paying full market value. Option C. The disclosure is needed only after the deed is recorded. Option D. Only the buyer's lender must be told about the license. The correct answer is option A. The licensee must affirmatively disclose the license status and the capacity in which the licensee is acting. A Minnesota licensee who acquires or intends to acquire an interest in real property must disclose the license status and capacity before negotiation or consummation. Paying market value does not remove the conflict risk, and post-recording disclosure would be too late. Lender-only notice does not satisfy disclosure to the property owner. Question 70. For Morgan Thompson's first real estate job in Brainerd, who submits the Minnesota salesperson license application after the applicant becomes associated with a broker? Option A. The applicant directly through a personal account only. Option B. The licensed real estate broker with whom the applicant is associated. Option C. The listing client from the applicant's first transaction. Option D. The county recorder in the county where the applicant lives. The correct answer is option B. The licensed real estate broker with whom the applicant is associated. A Minnesota salesperson must be associated with a licensed broker, and the broker submits the license application. The applicant alone does not file the salesperson application, clients have no filing role, and county recorders do not issue salesperson licenses. Broker sponsorship is central to salesperson licensure. Question 71. When Skylar Patel buys a condominium unit in Eagan, what does the buyer typically own? Option A. Only a stock certificate and no real property interest. Option B. The entire building in severalty. Option C. The individual unit plus an undivided interest in the common elements. Option D. A temporary license to occupy the unit. The correct answer is option C. The individual unit plus an undivided interest in the common elements. Condominium ownership generally includes the individual unit and an undivided interest in common elements. A cooperative usually involves shares and a proprietary lease, not condominium ownership. The buyer does not own the whole building alone or merely hold a temporary license. Question 72. A property loses value because its floor plan is outdated compared with modern buyer expectations. What type of depreciation is most likely for Rowan in Mankato involving a single-family home priced at $438,000? Option A. Accretion. Option B. Economic rent. Option C. Constructive notice. Option D. Functional obsolescence. The correct answer is option D. Functional obsolescence. Functional obsolescence is loss in value from outdated design, layout, or utility within the property. Accretion is land buildup, economic rent is market rent, and constructive notice comes from public records. The problem is the property's function. Question 73. A deed is signed by the grantor but never delivered to Morgan Okafor. Why is delivery important? Option A. Delivery shows the grantor's intent that the deed take effect. Option B. Delivery sets the mortgage interest rate. Option C. Delivery replaces legal description requirements. Option D. Delivery creates a leasehold only. The correct answer is option A. Delivery shows the grantor's intent that the deed take effect. A deed must be delivered and accepted to operate as a conveyance. Delivery reflects the grantor's intent that the instrument take effect. It does not set loan terms, replace the legal description, or create only a leasehold. Question 74. If a seller rejects Casey Garcia's offer and the listing broker holds the earnest money, when should the rejected offer's earnest money be returned? Option A. Only after the seller signs a different purchase agreement. Option B. No later than the next business day after rejection. Option C. At the end of the listing period. Option D. After the broker deducts marketing expenses. The correct answer is option B. No later than the next business day after rejection. When an offer is rejected, Minnesota trust account rules require earnest money to be returned to the potential buyer no later than the next business day after rejection. The broker cannot hold it until another sale, listing expiration, or reimbursement of marketing costs. Rejected offers do not create a right to keep the buyer's funds. Question 75. During negotiations in St. Paul, Sawyer Anderson changes the price and closing date in the seller's offer. What is the legal effect of that response? Option A. It is an acceptance because some terms stayed the same. Option B. It creates a lease instead of a purchase contract. Option C. It is a counteroffer that rejects the original offer and proposes new terms. Option D. It keeps the original offer open forever. The correct answer is option C. It is a counteroffer that rejects the original offer and proposes new terms. Changing material terms creates a counteroffer rather than an acceptance. The original offer is rejected unless the offeror renews or accepts the new terms. Keeping some terms unchanged does not preserve the original offer forever or convert the transaction into a lease. Question 76. Under Minnesota licensing rules, what happens when a salesperson's association with an actively licensed broker ends for Avery in Northfield involving a duplex priced at $412,500? Option A. The salesperson may continue independently for 90 days. Option B. The salesperson automatically becomes a limited broker. Option C. The salesperson may transfer clients without broker supervision. Option D. The salesperson's license becomes inactive until proper association is restored. The correct answer is option D. The salesperson's license becomes inactive until proper association is restored. A salesperson license depends on active association with a licensed broker. Ending that association makes the license inactive, so independent practice is not allowed. Automatic broker status and unsupervised client transfers are not part of the salesperson licensing structure. Question 77. Why should a purchase agreement for a mixed-use property in Mankato be in writing and signed by the party to be charged? Option A. The statute of frauds requires most real estate sale contracts to be in writing to be enforceable. Option B. All oral contracts are criminal offenses. Option C. Only lenders may sign real estate contracts. Option D. A deed is unnecessary if the parties shake hands. The correct answer is option A. The statute of frauds requires most real estate sale contracts to be in writing to be enforceable. The statute of frauds generally requires contracts for the sale of real property to be in writing and signed by the party to be charged. Oral agreements may fail enforceability even if the parties intended a deal. Lender-only signatures and handshake transfers do not replace the required written contract and later conveyance documents. Question 78. A parcel borders a lake near Bemidji. Rights associated with use of the lakeshore are commonly called what for Finley in Bemidji involving a condominium unit priced at $194,500? Option A. Riparian rights only. Option B. Literal rights. Option C. Fixture rights. Option D. Novation rights. The correct answer is option B. Literal rights. Literal rights generally relate to property bordering lakes, seas, or oceans. Riparian rights involve rivers and streams, fixtures concern attached property, and novation is contract substitution. The lakefront fact drives the answer. Question 79. A Woodbury buyer's loan has small monthly payments but one large final payment. What is that final payment called for Drew in Woodbury involving a lake cabin priced at $220,500? Option A. Proration credit. Option B. Replacement reserve. Option C. Balloon payment. Option D. Equity dividend. The correct answer is option C. Balloon payment. A balloon payment is a large unpaid balance due at the end of a loan term. A proration credit divides expenses at closing. A replacement reserve funds future repairs, and an equity dividend is an investment return measure. The structure described is a financing feature. Question 80. A buyer's lender evaluates income, credit, and property value without discrimination. Which law commonly governs equal access to credit for Emerson in Duluth involving a farm parcel priced at $436,500? Option A. Statute of Frauds. Option B. Truth in Zoning Act. Option C. Rule against perpetuities only. Option D. Equal Credit Opportunity Act. The correct answer is option D. Equal Credit Opportunity Act. The Equal Credit Opportunity Act prohibits discrimination in credit transactions based on protected characteristics. The statute of frauds concerns enforceability of certain contracts, and zoning or perpetuity concepts are unrelated to lending equality. Financing decisions must focus on lawful underwriting factors. Question 81. During a Minneapolis license renewal review, which continuing education schedule best matches Minnesota salesperson requirements for Reese in Minneapolis involving a lake cabin priced at $350,000? Option A, 30 hours before the June 30th renewal deadline, with at least 15 hours completed before the previous June 30th. Option B, 10 hours every 4 years with no annual deadline. Option C, 30 hours only during the first licensing year. Option D, only the required module with no other continuing education. The correct answer is option A, 30 hours before the June 30th renewal deadline, with at least 15 hours completed before the previous June 30th. Minnesota salespersons generally need 30 hours of continuing education before the June 30th renewal deadline, with at least 15 hours due before the previous June 30th. The other options understate the hours, remove the annual structure, or treat the module as the only requirement. Continuing education must be completed in the proper license period. Question 82. Which appraisal approach is usually most persuasive for a typical owner-occupied home in a subdivision with many recent comparable sales for Quinn and Eden Prairie involving a condominium unit priced at $301,000? Option A, cost approach only. Option B, sales comparison approach. Option C, income approach only. Option D, front foot method only. The correct answer is option B, sales comparison approach. The sales comparison approach is usually strongest when similar properties have sold recently in the same market. The cost approach can be useful for new or special purpose improvements, and the income approach is more relevant to income-producing property. Front foot analysis is a land valuation tool, not the main method for a typical home. Question 83. A rumor says a Winona home was once the site of a natural death and possible paranormal activity. Under Minnesota disclosure rules, how is that fact treated? Option A, it must always be disclosed in the listing contract. Option B, it makes the property unmarketable until court approval. Option C, it is not treated as a material fact that must be disclosed merely for that reason. Option D, it requires the buyer to receive a separate environmental report. The correct answer is option C. It is not treated as a material fact that must be disclosed merely for that reason. Minnesota law states that certain stigmatizing facts, such as suicide, natural death, or perceived paranormal activity, are not material facts requiring disclosure merely because they occurred. That does not change the duty to disclose physical defects or other material facts. Listing contracts, court approval, and environmental reports address different issues. Question 84. An appraiser subtracts curable physical deterioration and functional obsolescence from replacement cost. Which approach is being used for Casey and Stillwater involving a farm parcel priced at $433,500? Option A, sales comparison approach only. Option B, income approach only. Option C, gross rent multiplier only. Option D, cost approach. The correct answer is option D, cost approach. The cost approach estimates land value plus improvement cost minus depreciation. Sales comparison relies on comparable sales, and income analysis capitalizes income. Depreciation from replacement cost is the clue. Question 85. An older commercial building in Mankato may contain asbestos insulation. What should the licensee avoid doing for Rowan in Mankato involving a single-family home priced at $289,500? Option A, giving a technical safety opinion beyond the licensee's expertise. Option B, recommending qualified inspection or environmental advice. Option C, disclosing known material facts. Option D, using written reports from qualified professionals. The correct answer is option A, giving a technical safety opinion beyond the licensee's expertise. Asbestos concerns should be handled with qualified inspection and proper disclosure of known material facts. A licensee should avoid technical safety opinions outside the real estate role. Professional reports and disclosure are safer than speculation. Question 86. For a pre-1978 residential property, what federal disclosure issue should a licensee remember for Hayden in Rochester involving a newly built townhouse priced at $268,000? Option A, the property can never be sold. Option B, lead-based paint disclosure requirements may apply before the buyer or tenant is obligated. Option C, only commercial buyers receive the pamphlet. Option D, lead disclosure replaces all agency disclosure. The correct answer is option B. Lead-based paint disclosure requirements may apply before the buyer or tenant is obligated. Federal lead-based paint rules apply to many pre-1978 residential transactions and require disclosure before the buyer or tenant is obligated. The rules do not ban every sale or limit disclosure to commercial buyers. Lead disclosure is separate from agency disclosure and material fact duties. Question 87. A buyer asks about radon during a Rochester home purchase. What is the safest professional response for a licensee? Option A, guarantee that radon is never a concern in Minnesota. Option B, tell the buyer to ignore radon because it is a title defect. Option C, provide required or available radon information and recommend appropriate testing or qualified advice rather than guaranteeing levels. Option D, prepare a scientific certification without testing. The correct answer is option C. Provide required or available radon information and recommend appropriate testing or qualified advice rather than guaranteeing levels. Radon is an environmental concern that should be addressed with required information, testing, and qualified resources. A licensee should not guarantee levels or provide scientific certification without proper expertise. Radon is a physical/environmental issue, not a title defect. Question 88. A property has monthly gross rent of $1,425 and sells for $178,125. What is the gross rent multiplier? Option A, 6.5%. Option B, 6.5%. Option C, 80%. Option D, 125.0. The correct answer is option D, 125.0. Gross rent multiplier is price divided by gross rent for the same period. Cap rate, commission rate, and loan-to-value percentage measure different relationships. GRM is a quick income property comparison tool, not a complete valuation method. Question 89. If an override clause appears in Morgan Rivera's listing agreement, what must the licensee provide within 72 hours after the listing expires for the clause to be effective for Blair in Bloomington involving a vacant lot priced at $218,500? Option A, a protective list. Option B, a new deed. Option C, a county tax appeal. Option D, a mortgage payoff statement. The correct answer is option A, a protective list. An override clause is tied to a protective list supplied within the required time after expiration. A deed, tax appeal, or payoff statement does not preserve the broker's override rights. The protective list identifies prospects covered by the clause. Question 90. A homestead classification question appears on a Minnesota practice exam. What topic is being tested most directly for Kendall in Winona involving a townhome priced at $355,000? Option A, federal lead paint pamphlet rules only. Option B, property tax and ownership status treatment. Option C, advertising font size only. Option D, dual agency consent wording only. The correct answer is option B, property tax and ownership status treatment. Homestead classification generally relates to property tax and ownership or occupancy status. Lead paint, advertising, and dual agency are separate real estate topics. Exam questions may connect homestead status with tax treatment and ownership rights. Question 91. A Eden Prairie parcel contains 3 acres. How many square feet are in the parcel? Option A, $25,200. Option B, $298,875. Option C, $130,680. Option D, $5,081. The correct answer is option C, $130,680. 1 acre contains 43,560 square feet, so acreage is converted by multiplying acres by 43,560. Frontage value, loan amount, and tax amount are calculated from different data. Unit conversion is a common real estate math task. Question 92. Wetlands are suspected on a vacant Carver County parcel. What should a licensee recommend before development assumptions are made for Taylor in Maple Grove involving a rental house priced at $222,000? Option A. Assume all wetlands can be filled without approval. Option B. Use only the buyer's preferred building sketch. Option C. Ignore wetlands because they affect only personal property. Option D. Obtain qualified advice about wetland restrictions and permitting. The correct answer is option D. Obtain qualified advice about wetland restrictions and permitting. Wetland restrictions can limit development and require permits or expert review. Assuming fill is allowed or relying only on a sketch creates risk. Wetlands are real property and land use issues, not merely personal property concerns. Question 93. A restaurant tenant installs removable ovens for the tenant's business. What are those items often called for Emerson in Duluth involving a condominium unit priced at $225,500? Option A. Trade fixtures. Option B. Riparian rights. Option C. Deed restrictions. Option D. Remainders. The correct answer is option A. Trade fixtures. Trade fixtures are business-related items installed by a tenant and usually removable if removed timely and damage is repaired. Riparian rights concern water, deed restrictions limit property use, and remainders are future interests. The tenant's business equipment points to trade fixtures. Question 94. A borrower gives a mortgage on a Red Wing property while retaining possession. What financing concept lets the borrower pledge the property without surrendering it? Option A. Avulsion. Option B. Hypothecation. Option C. Emblements. Option D. Accession. The correct answer is option B. Hypothecation. Hypothecation means pledging property as security for a debt while retaining possession. Avulsion and accession concern land or property changes, while emblements are crops. Mortgage lending commonly uses hypothecation. Question 95. While interviewing with two firms in St. Paul, Sawyer asks how many Minnesota brokers may supervise the salesperson during the same period. Option A. 2 brokers if both brokers consent. Option B. Any number of brokers if the salesperson discloses the arrangement. Option C. 1 actively licensed broker. Option D. 1 broker for residential sales and a separate broker for leases. The correct answer is option C. 1 actively licensed broker. A salesperson in Minnesota is licensed to act on behalf of 1 broker during the same period. Consent or disclosure does not create authority to work under multiple brokers. Splitting residential and leasing work between brokers would still violate the Single Broker Association rule. Question 96. A $211,000 sale carries a 6% commission. What is the total commission before any split? Option A. $21,100. Option B. $1,899. Option C. $2,532. Option D. $12,660. The correct answer is option D. $12,660. Total commission is found by multiplying the sale price by the commission rate. Down payment, discount points, and property tax calculations use different bases. The phrase before any split means the full brokerage commission is calculated first. Question 97. Why might Harper Davis use a quitclaim deed to clear a possible title issue? Option A. It transfers whatever interest the grantor may have without making title warranties. Option B. It guarantees the property is free of every lien. Option C. It creates a new mortgage automatically. Option D. It replaces the need for delivery and acceptance. The correct answer is option A. It transfers whatever interest the grantor may have without making title warranties. A quitclaim deed can release or transfer any interest the grantor may have, but it does not warrant title quality. It does not guarantee lien-free ownership or create a mortgage. Like other deeds, it still depends on proper execution, delivery, and acceptance. Question 98. A legal description identifies a lot and block in a recorded subdivision plat. Which description method is used for Rowan and Mankato involving a lake cabin priced at $366,000? Option A. Rectangular survey only. Option B. Lot and block. Option C, a monumentless description. Option D, a front foot appraisal. The correct answer is option B, lot and block. Lot and block descriptions rely on a recorded subdivision plat. Rectangular survey uses sections, townships, and ranges, while front foot appraisal values frontage. The presence of a recorded plat points to lot and block. Question 99. A lender must disclose the cost of consumer credit so borrowers can compare loan terms. Which federal law is most directly involved for Emerson in Duluth involving a vacant lot priced at $442,000? Option A, Sherman Antitrust Act only. Option B, Clean Water Act only. Option C, Truth in Lending Act. Option D, Minnesota Torrens Act only. The correct answer is option C, Truth in Lending Act. Truth in lending requires disclosure of credit terms such as APR in many consumer loans. Antitrust, environmental, and Torrens land registration laws address different areas. The question focuses on loan cost disclosure. Question 100. A neighbor receives permission to park on Parker and Wen's land for 1 weekend only. What interest is most likely created? Option A, easement appurtenant. Option B, fee simple estate. Option C, a mechanic's lien. Option D, license. The correct answer is option D, license. A license is personal permission to use property and is generally revocable. An easement appurtenant is a more durable interest tied to benefited land, fee simple is ownership, and a mechanic's lien secures payment. Temporary parking permission is a license.